A California family can inherit a home and still be forced to sell it, not because they lost the house, but because the new tax bill no longer fits the life built around it.
One-year rule. The family home test. The trust myth.
There's a moment in a lot of California families that nobody really plans for. A parent passes away. The kids, now adults, sit down with the paperwork, and somewhere in that paperwork is the family home. The house they grew up in. The house their parents bought decades ago when prices in California were a different conversation entirely. And a lot of families assume the same thing. They assume the low property tax bill, the one their parents have been paying for 30 or 40 years, just passes to them along with the house. For decades, that was true. Under California's older rules, the family home, and even rental properties up to a certain value, could be passed from a parent to a child without the property tax being recalculated. That changed on February 16, 2021. Since that date, California has been operating under a different rule, a rule that has very specific conditions. And many families don't focus on those conditions until the property tax bill arrives, and by then, the clock is already running. I'm going to walk you through what this rule actually is, not what people argue about online, what the state of California, through the Board of Equalization and the Secretary of State, actually says it is. I want to be clear about something before we go any further. I'm not going to tell you whether a certain ballot initiative is going to qualify or fail, or what the politics of any of this should be. I can't know that. And to be honest, neither can anyone else who's being honest with you. What I can tell you is what the rule actually is right now, because that's what affects your family this week, this month, and this year, regardless of any future ballot measure. So treat this less as a news video and more as a kind of homeowner field guide, something to keep in the back of your mind, or send to a sibling, or bring up the next time you sit down with your parents at the kitchen table, before there's any reason to. Let's start with why this is even in the news again. If you've heard about Proposition 19 lately, it's probably because a ballot initiative effort to repeal part of it has moved into the signature count stage. Here's what the public record says about that initiative, and I'm pulling this directly from the California Secretary of State. The Attorney General's official title for this measure is Repeals Voter-Enacted Changes to Property Tax Rules for Transfers Between Family Members. It's an initiative constitutional amendment, tracking number 25-0017. According to the Secretary of State's current status page, the measure is now listed as pending raw count of signatures. The raw count deadline is May 15, 2026, and the number of signatures required remains 874,641 for the measure to move forward in the qualification process. The legislative analyst and the director of finance have estimated that, if the measure qualified and passed, it would reduce revenue for local governments and schools by around $1 billion per year in the first few years, growing to around $2 billion annually over time. According to news coverage, this is at least the third attempt to repeal Proposition 19's inheritance changes. Earlier petitions in 2022 and 2024 fell short of the required signatures. But here's the thing. Whether this initiative moves past the raw count stage, fails later in the process, qualifies for the ballot, or is ultimately rejected by voters, the rule it is trying to undo is still the rule that governs your family home today, tomorrow, and every day until something actually changes. So that's what we're going to walk through. The rule, not the news. To understand why families are getting caught, you have to understand what Proposition 19 actually changed, because it didn't just tweak the rules, it rewrote them. Under the older law, that's Propositions 58 and 193, which had been in place since the 1980s and 1990s. When a parent transferred their principal residence to a child, the child kept the parent's tax base. There was no value limit on the home, and on top of that, parents could transfer up to $1 million of factored base year value of other real property. rental homes, vacation homes, to their kids without the property being reassessed. Under Proposition 19, that changed in two big ways. First, the principal residence exclusion now requires that the home be the principal residence of the parent and become the principal residence of the child. Plus, there's a value limit, the current taxable value, plus a $1 million adjustment that increases over time. Second, and this is the part most families don't know about, the exclusion for other real property, the rentals and vacation homes, was eliminated entirely. That row basically deleted itself. This change took effect on February 16, 2021. The implementing statute is Revenue and Taxation Code Section 63.2, added by Senate Bill 539 in 2021. That's the source of everything we're about to walk through. So now, with that foundation, let's go through the 4 places where families actually get caught. I'm going to call them traps. Not because anybody is trying to trick anyone, but because these are the conditions where families assume the old rule still applies and find out, often too late, that it doesn't. Trap 1 is this. The Parent-Child Exclusion is no longer automatic. Under Proposition 19, 3 conditions all have to be true. 1. The home has to have been the parent's principal residence. 2. The child has to make it their principal residence, and that has to be confirmed by filing for the homeowner's exemption within 1 year of the transfer. And 3, the value cap determines how much of the old tax base can be preserved. Let's talk about that cap, because this is the part that's been changing. Per the Board of Equalization, for transfers occurring between February 16, 2025 and February 15, 2027, which is the window we're in right now, the exclusion amount is $1,044,586. That number adjusts every 2 years. But, and this is where most viewers get the math wrong, that number is added to the parent's factored base year value. It's not compared to the home's market value alone. So let me walk you through an example. This is an illustration, not a specific case. The exact numbers will be different for every home, in every county, with every set of circumstances. So please treat this as math, not as a prediction. Imagine a home where the factored base year value, the parent's tax base value, is $300,000, and the fair market value at the time of transfer is $1.5 million. Under the current exclusion, you take the $300,000 and add the $1,044,586. That gives you the excluded amount, about $1.34 million. The fair market value is $1.5 million, so the excess, about $155,000, gets added to the original $300,000. The new adjusted base year value comes out to roughly $455,000. Using a roughly 1.1% effective property tax rate as a rough baseline, and your actual rate depends entirely on your county and any local assessments, that's the difference between roughly $3,300 a year and roughly $5,000 a year. If the heir moves in within a year and files the right form. If they don't move in, if they keep it as a rental, or sell it, or just leave it sitting, then per the Board of Equalization, the home gets reassessed to its full fair market value. In this illustration, that's the full $1.5 million. And one more thing in this trap that a lot of people don't know. If the home is inherited by multiple siblings, the Board of Equalization confirms that only one of them needs to live in it and file the homeowner's exemption for the exclusion to apply to the property. Not all of them, just one. Trap 2 is shorter, but it catches a lot of families. If the property your parents are passing to you is a rental, or a vacation home, or any property that wasn't their primary residence, the Parent-Child Exclusion does not apply. At all. That's directly from the Board of Equalization. The exclusion under Proposition 19 covers 2 things: a family home that is the principal residence of the parent and becomes the principal residence of the child, or a family farm. That's the list. Under the old law, parents could pass up to $1 million of factored base year value of other real property to their kids without reassessment. A lot of California parents bought rental properties decades ago believing that was how it would work for their kids too. As of February 2021, that exclusion is gone. This isn't a question I can solve for you in a YouTube video. And frankly, it's not one a YouTube video should solve for anyone. If your family has rental property that may someday transfer between generations, this is a conversation for a California estate planning attorney and a CPA, not a comment section. Trap 3 is the one that even families who do qualify for the exclusion sometimes miss, because there isn't one form to file. There are two, and they have two different deadlines. The first form is either BOE 266, the claim for homeowners property tax exemption, or BOE 261G, the claim for disabled veterans property tax exemption. This is the form that proves the property is actually the heir's principal residence. Per the Board of Equalization, this form has to be filed within 1 year of the date of death or transfer. And here's the part that's commonly misunderstood. If you file it late, you don't lose the exclusion entirely. The Board of Equalization specifies that the exclusion will apply prospectively from the late filing date, not retroactively to the transfer. The second form is BOE 19P. That's the one that's named very specifically Claim for Reassessment Exclusion for Transfer Between Parent and Child, occurring on or after February 16, 2021. This form has to be filed within 3 years of the date of death or transfer, or before the home is sold to a third party, whichever comes first. For grandparent to grandchild transfers, the equivalent form is BOE 19G. Same structure. Both forms get filed with the county assessor of the county where the property is located, not the state, the county. So one form proves you live there. The other form claims the exclusion. You need both, and the deadlines are different. If anybody in your family is in this situation, this is something to confirm with your county assessor's office directly. They handle the actual paperwork. And again, talk to an estate planning attorney before you assume any of this is straightforward. This is one of the questions that comes up most often under videos like this. Some version of, "But my parents put the home in a trust. Doesn't that fix it?" According to the Board of Equalization, the answer is no, not by itself. Here's why. For property held in a trust, a change of ownership for property tax purposes generally happens when the interests in the property vest in someone other than the truster. Typically when a revocable trust becomes irrevocable, which usually happens at the truster's death. The legal citation for that is Revenue and Taxation Code Section 61H and Property Tax Rule 462.260. Both confirmed on the Board of Equalization's Proposition 19 page. The Board of Equalization's own guidance is enough here. A trust, by itself, does not make Proposition 19 disappear. Now, I want to be careful here. Trusts do a lot of useful things in estate planning that have nothing to do with Proposition 19. They help families avoid probate. They give privacy. They can simplify the process for heirs. Those benefits are real. But if your family is sitting down with a trust thinking it's going to make Proposition 19 disappear by itself, based on what the Board of Equalization actually says, that's not what a trust does on its own. The specific strategies people sometimes ask about in the comments, irrevocable trusts, LLCs, gifting before death, those are very specific tax planning conversations, and they belong with a qualified California estate planning attorney, not in a video like this one. Now, before we walk out, I want to be fair to Proposition 19, because it's not all takeaway. There's a part of Proposition 19 that's actually a tax cut, not a tax hike. And most viewers don't even know it exists. Under Proposition 19's other half, Revenue and Taxation Code Section 69.6, California homeowners who fall into one of 3 categories can transfer the base year value of their primary residence to a replacement primary residence anywhere in California. Those 3 categories: homeowners who are age 55 or older, homeowners who are severely and permanently disabled, and victims of a wildfire, as defined, or a governor-declared natural disaster, and they can do this up to 3 times in their lifetime. That's a real expansion. Under the older law, Propositions 60, 90, and 110, base year value transfers were limited to once, and they were generally restricted to the same county or to a small list of participating counties. Proposition 19 made it 3 transfers anywhere in California. The relevant forms are BOE 19B for age 55 and over, BOE 19D, and BOE 19DC for severely and permanently disabled homeowners, and BOE 19V for victims of wildfire or other natural disaster. All of those have to be filed within 3 years of the replacement home's purchase or completion. This part of Prop 19 took effect on April 1st, 2021. So when people talk about Prop 19 as if it's all one thing, it isn't. Half of it tightened the Parent-Child Exclusion. The other half expanded portability for retirees, disabled homeowners, and disaster victims. Both halves are in force today. So what do you actually do with all of this? I'm not going to tell you what your move should be. I'm not your lawyer. I'm not your CPA. I'm not your estate planner. And the goal of this video is to make a 30-minute conversation with one of those people more productive, not to replace it. But here are 6 questions, in plain English, worth carrying into that conversation. 1. Is the home your parents' principal residence? If yes, the Parent-Child Exclusion is potentially available. If it's a rental or a vacation home or a second home, the exclusion under Proposition 19 doesn't apply. 2. Will you or a sibling make it your principal residence within a year? Only one heir needs to move in for the exclusion to apply to the property. 3. What's the factored base year value versus the fair market value? The gap determines how much of the exclusion shields you and how much excess gets added to the new tax base. 4. Have you talked to your county assessor's office? They handle the actual filings and can tell you exactly what they need and how long it takes. 5. Have you talked to a California estate planning attorney and a CPA, trusts, gifting, ownership structure decisions? These are professional conversations. 6. Are you 55 or older, disabled, or a disaster victim? If so, do you know about base year value portability? Up to 3 transfers anywhere in California. I want to leave you with one thought. The reason I cover this rule the way I do isn't because it's complicated. There are property tax codes in this country that are genuinely more complicated than Proposition 19. It's because it's quiet. The middle-class California family doesn't usually meet Proposition 19 until a parent dies. By then, the 1-year clock on the homeowner's exemption is already running. The decision about who moves in, who can move in, who has the life flexibility to move in, is being made in the worst week of the family's year. That's the hidden mechanism, not a tax calculation. The fact that the calculation only shows up at the moment families are least able to deal with it. In California, inheriting the family home is no longer just a family decision. Under Proposition 19, it can become a residency test, a filing deadline, and a property tax calculation. All at the same time, all on a clock you didn't know was already counting down. That's the whole reason this video exists. So that whatever happens with the raw count deadline this May, with future ballot measures, with future court cases, or future legislation, your family already knows the rule that's currently on the books, before you need it, not after. If this was useful, here's what I'd love to hear from you in the comments, and only answer the questions you want to. 1. Did you know about the 1-year homeowner's exemption deadline before this video? Yes or no? And 2, has Prop 19 shown up in your family yet in any form? Without naming names, without any specifics, just whether the rule has touched your life. Your answers help me figure out which California real estate rules to break down next. I'll see you in the next one.